Is the department able to give me a sense of how many organisers have been removed from the Victorian branch since the administration? I think there was a note that there were 26 staff exiting in the last couple of weeks.
Yes, as part of, I think, I referred to the letter from the administration to the Fair Work Commission General Manager that said there'd been 61 that had gone since the start of it. I don't have a breakdown as to their roles. I'll just check if Ms Anderson does.
No, I don't have the details of those, but 61 is our understanding.
Would you have the access to that information, and would you be able to provide that on notice?
No, well, to answer the first part of the question, we don't have the information now, so we'd be unable to provide it on notice. We'd have to seek it separately. It's the type of information. I think the stats in relation to New South Wales and Queensland, and we discussed it last estimates, were in the administrator's second biannual report, so it's the type of information he'd put in his 6-monthly reports normally.
Okay. And I'm just now looking at the letter from Mr Smith to the Minister on the 18th of November regarding his resignation from the National Construction Industry Forum. Could you tell me whether the Minister met with or discussed with Mr Smith his role prior to his resignation from the NCIF, noting that I did ask previously whether it was the Minister that sought his resignation or whether he resigned independently?
Not that I'm aware, Senator. I don't know.
Yeah. So, to your knowledge, there was no discussion or meeting with the Minister and Mr Smith?
There's no discussion I'm aware of. Can I just confirm that I think that was a letter you asked us to table by the end of the day? You've got it independently.
It's just been tabled. I don't know who by.
Okay. All right.
Yeah. Thank you. Is that tabled by you?
No.
Oh.
I don't have a copy with me, so no. I don't. No. I've read it. So if we're going to ask questions about the specifics of it, I'll need a copy. But if it's about it generally, then I may not.
Okay. Sure. Perfect.
It's one on its way now.
Okay.
So are you able to just give me? I'm interested in the timeline.
Thank you.
So you've confirmed that this was all independent. There was nothing from the Minister. So there's no directive from the Minister, no request, no discussion, just Mr Smith has resigned from the Labor Party National Executive and then from the NCIF, but there was no direction from the Minister.
So did you mention that Labor Party National Executive?
Yes.
It's not a matter of any knowledge
comment.
of?
I'm not a question. I made the comment.
Yeah.
It's part of my statement. I understand that is not part of the department's role.
Yeah. So
the balance of the question is, however,
as far as I'm aware, there's this letter in which Mr Smith puts forward that he's leaving due to the size of a task he's got in rebuilding and the branch which he's now responsible undertaking cultural change. And in a way, we spoke earlier about Mr Irving being appointed to the National Construction Industry Forum. And I think it's actually quite timely in the sense that forum is turning its mind to culture of the industry across the country. He's undertaking work on an industry charter that's focused on that. And given that Mr Irving has that responsibility for the union across the country, it got quite a timely appointment in that aspect. He was attending. He had a standing invitation to attend anyway, but I think it's probably certainly worthwhile, and as I say, timely that he's been approved now. He's got a strong interest in the industry, in the charter, the industry charter, and has attended a workshop on that already. But I've no other information about Mr Smith's resignation other than what he states in the letter.
Yeah, that's fine. I would suggest that it would have been timely at the inception of the administration, but I take your point. Given the scrutiny around Mr Smith's presence on the NCIF, why didn't the Minister announce the change? Why wasn't there an awareness of this resignation prior to today in my questions to you?
I'm not aware of the Minister's thinking in relation to it. It's, as Ms Anderson outlined earlier, there's been a range of changes.
None have been as contentious as this one, I would suggest.
No, but I think the point Mr Manning's making is that there have been numerous changes to the membership of this, and I'm not aware of the Minister announcing any of them. So,
but none of them...
I don't mean this in the way it's probably going to sound, but just because certain people have got an interest in one member of that doesn't mean that a Minister has to jumped to that and put out a press release. Like, memberships of bodies change from time to time without announcements being made.
Yeah, I guess the question is that this is contentious and there's quite a high degree of public interest in it, which might be different to the appointments and the changes of other members. So I was just curious as to, whether that was even a consideration.
I might just note, though, as well, and understand that the letter may be tabled from Mr Irving to the Fair Work Commission, though, but my understanding of that letter too outlines as we sort of indicated before, the confidence and support that Mr Irving has for Mr Smith, and I think the letter goes to, and again it would be outlined in that letter, but also noting that there are a range of players in the industry too that are sort of, I suppose, seeking to sort of undermine the role of the administrator and the people that are key to the success of the administration as well. And Mr Irving has highlighted that point in his letter, as well as the fact that Mr Smith is there to, as he indicates in his resignation letter, to effectively drive change within the Victorian branch as well. So I'll just note that.
And you'll see, Senator, and you may have mentioned this already, that it's not just the NCIF that Mr Smith has resigned his membership of. He's also resigned his membership of the Asbestos and Silica Safety and Eradication Council, and based on what he's saying here, it's a workload issue because of the main task he has in his words, rebuilding and the culture change that is required in the union.
I note that Mr Smith is still noted on the website as a member of the NCIF. How long does it take to make that change? I'm just curious that it's remained silent until today.
Is that the department's website are you referring to, Senator?
Correct, yes. Yeah.
Senator, it may be, I'd have to probably take it on notice, but we would seek to be updating the website.
Okay, all right. Yeah, because the other changes have been made in relation to Minister O'Neill and Lucy Webber, but the change in relation to Mr Smith hasn't been made.
Mr Smith and Mr Irving.
Yeah, and Mr Irving was only appointed yesterday.
Yes, well, I'm not asking about that one. Yeah. I'm asking about Mr Smith. The resignation was on the 18th of November. Was there any request to keep that quiet for a period of time from anyone?
No, Senator. No.
Okay. Thank you. And I'm just thinking about the self-removals from the CFMEU and the fact that Mr Smith was offering redundancies to members who knew of or were engaged in inappropriate or corrupt conduct. Does the Minister think it's appropriate for him to remain in that role, given those circumstances?
In which role?
In his role at the CFMEU, given he's now, no longer on the NCIF, he's been removed from the Labor Party State Executive. I
think I'd say generally that the Minister's view and the government's view is that staffing decisions of the CFMEU are matters for the administrator, and we've got full confidence in his decision making. So you don't hold a view as to the appropriateness of an individual where that information has come to light? I don't think we have a habit of going around telling organisations who they can and can't employ. It's a matter for the employer, and in this case that's the administrator. And I think you can look at the very large number of people who the administrator has removed as a demonstration that where there are good grounds for someone to be removed, then he takes action. Thank you. I do know that one of those people was removed after he was promoted by the administrator as well, despite those allegations allegedly being live at the time. Well, I think there's different versions of that, but he has, in the last 2 weeks alone, the administrator has removed, I think it's upwards of 20 people? 26 people in Victoria. 26 people just from the Victorian branch, and that's in addition to the dozens who he's removed from the New South Wales and Queensland branch and other branches as well.
And it is worth perhaps, Senator, repeating the evidence we gave earlier that there were specific questions put to the administrator by the Fair Work Commission General Manager which he addressed, and in that, having looked at all of these factors, expressed very strong confidence in Mr Smith and his support for the proper operation of the administration as well. Okay.
I asked a question before the break about Mr Setka's union membership. The Administrator told the Commission of Inquiry that he intended to terminate Mr Setka's membership. Is it a bit unusual that he still holds that membership in your view, or do we have any understanding about why it's taken the Administrator so long to terminate his membership?
I know a little bit about the Administrator, and I know a little bit about the administration. I know about the fact that the Administrator has been subject to death threats, has sacked dozens of people from the CFMEU, has done more to clean up the CFMEU than the ABCC ever did in its decade of operation. I think it's a little bit rich, and I know you're being asked to ask some of these questions, Senator, but I think it's a little bit rich to expect the Administrator, in the time that he's been there, to attend to every single detail. He has done a power of work to stand up to the corrupt elements of this union, and I might add, he's doing everything he can to stand up to the corrupt elements within the employers of Australia, which no one in the Liberal Party ever seems to want to ask questions about, and that where there is a huge amount to be done. So if people want to be critical of the Administrator for the sequence in which he's doing things, then they have no appreciation of the incredible pressure and workload that those people have been undertaking since they started.
Minister, I acknowledge the scale of the work that the Administrator has at hand, and it is significant. And they literally put their lives on the line. Yeah, I note your comments in relation to the death threats, and they are absolutely unacceptable, and nobody should be subject to that in the carriage of their work. And I don't think anyone is suggesting that that is right or reasonable, or that anybody should put up with that. I guess, like, just from a very basic level, the question is, it is one singular act to remove Mr Setka from the CFMEU, so it was just to gather an insight as to why that's something that hasn't occurred yet. And
I think the point I'm making, I guess, is that I think the Administrator and his team have made good judgments about what are the most urgent matters to deal with, and in their judgment, one of the most urgent matters to deal with was to sack dozens of bad elements within this union, and they've clearly then moved on to considering the expulsion of particular people, and no doubt there'll be other things that they do down the track as well. So, you know, they have really emerged from a crisis situation, and they are now dealing with additional matters. So I suspect that the reason they didn't move on the expulsions earlier was because they were very focused on actually removing people from the organisation, and all of the other things they've done up until now.
Yeah, I guess for the lay observer of this, individuals that don't have a lot of knowledge as to the operations of the union system, is that he's probably the most singular figure of the problems within the CFMEU, and perhaps it would send a very strong signal for him to be expelled from the CFMEU. So the question comes from that lens.
Sure. And as we understand, that is now occurring, that steps are being taken to expel a number of former officials from the union. And I can understand that for, as you say, the lay observer, you know, Mr Setka has got a lot more attention in the media than most others, but the problems went a lot deeper than Mr Setka, and they involve people that no one has ever heard of before and who are no longer officials of that union, and that's a good thing. Yeah, rightly or wrongly, he's the public figurehead perhaps, and that perception that sends that he's still there. But thank you for your answer, Minister. Has the department provided any advice to ASIC or the Minister regarding Incolink and similar funds, and whether they should now fall under Commonwealth regulation due to their scale, their governance concerns, or the risks to worker entitlements?
I'm aware that ASIC has recently completed or done some work on that in relation to the exemption. Mr Keynes has just joined us, might be able to help you with the question about whether or not we've given advice on that yet.
I can confirm, Senator, that we haven't provided advice directly to ASIC around Encode Is that, sorry, Senator?
Yeah, so in relation to have you provided advice to ASIC or the Minister in relation to IncoLink and similar funds and whether they should now fall under Commonwealth regulation because of the scale of those funds, the size of them, and obviously there are governance concerns in relation to that, and obviously potential risk to worker entitlements, that they are effectively self-managed?
Senator, to my understanding, ASIC has recently finished its review into worker entitlement funds. On the 26th of November, ASIC outlined its approach to the regulation of employee redundancy funds, which IncoLink is one of. So there is currently a relief to worker entitlement funds under the Corporations Act, and that expires on the 1st of April 2026. From that date, though, the changes that ASIC have outlined, I can take you through those, that operators of employee redundancy funds and long service leave funds will be required to apply for an Australian Financial Services licence and comply with some of the managed investment provisions of the Corporations Act. ASIC has stated that their approach will introduce additional transparency and governance requirements for these funds that reflect the significant increase in funds under management and a broadening of the scope of activities undertaken by some funds. And to assist fund operators in early 2026, ASIC will release further information on the transitional arrangements, the licence application process and requirements that will apply once a licence is granted. That's my understanding in terms of where they're up to. Right.
So do you know or do you have information as to whether IncoLink has in fact applied for a financial services licence?
So these arrangements commenced, my understanding, is from April 2026?
Yes, I'm aware, but do you have any awareness of whether...
No,
they haven't. So if they do not apply for a licence by that time, they will no longer be able to manage those funds. Is that correct?
I think they benefit from an exemption, as Ms Anderson outlined, and presumably that exemption wouldn't apply anymore. Given it's not an area I know what the particular consequence of that is.
No, so yeah, I'm just trying to understand from what was read out. I don't have the benefit of reading it.
Questions are probably better placed to ASIC or Treasury in terms of the
consequence.
Yeah.
Right. Are you able to table that information that you have there?
Yeah, I'm sure there's probably a media release.
I'm sure there is.
That was attached to this, and we could probably try and find that for you.
Thank you. Has the department been briefed by the CFMEU administrator, or Gordon Legal, or former Victorian Treasurer Tim Pallas regarding the ongoing investigation into the IncoLink grants and the significant valuation write-down of the $27 million wellness centre?
No, certainly I haven't had discussions with the administration about the detail of that. I'm aware it's happening, seen the media reports around it. I can't recall off the top of my head even if the engagement has been raised with us. So no.
Okay. Does the department have any concerns regarding the appointment of Tim Pallas, a former State Labor Treasurer, to conduct the review, given there's potential conflicts?
So our position on that would be similar to the position I outlined earlier, in the sense that we don't have concerns based on what we've seen about the judgment of the administrator to decide who to appoint to these things. So we're not aware of any particular issues with it, and again would leave that to the judgment of the administrator in relation to his work to get to understand the finances of that branch and the union as a whole.
Okay. I want to quote from an AFR article that was published yesterday. It says, "That's the same Pallas who was guest of honour at a CFMEU organised private lunch in 2022, which then union boss John Setka and outgoing IncoLink boss Eric Locke also attended. That same year, Pallas was also the guest of honour at a cosy dinner event hosted by IncoLink and posed for photos there alongside Locke." I mean, are we right to be worried as to whether this really is an independent review, and does the department have any concerns in relation to this?
So, again, Senator, what we've seen.
I know we're repeating ourselves.
No, but what we've seen from the Administrator General, like if we go back to the Watson reports, he seems able, in our experience, to engage people who properly understand integrity issues and a lot of conflict. The Administrator understands conflict of interest issues. I think I'd be surprised if he hadn't satisfied himself that Mr Pallas was a suitable person to do it, but I have no knowledge about those events that you're citing in the article. I don't know. I guess beyond them being reported, I don't have any knowledge.
I guess I'm not asking you to give statements in relation to the veracity or the accurateness of the reports. What I'm trying to get an understanding of is we have an independent review that's being led by somebody who is well known clearly to the individuals that he will be reviewing, given that he attended on 2 separate occasions, at least allegedly, a dinner. So if that were the case, is it normal in the department's view, or is it acceptable in the department's view, that an independent reviewer would be somebody that is actually connected to those that they are reviewing?
Yeah, again, from the department's perspective, based on what we've seen the administration do, we've got confidence that the administrator would properly consider these issues and act accordingly.
Okay, my assessment of independent is different, perhaps. Given the department's responsibility for workplace relations policy, what assessment has the department made about the risks to worker entitlements when funds mandated by union EBA clauses are used for union projects rather than for worker benefits, as I've described in that wellness centre, especially when the valuations diverge so sharply from grant amounts? The valuation came to, I believe, a third of that $27 million expenditure.
Senator, there's a lot in the question that you just asked. Is there a specific matter or allegation you want us to address? Because I think that the breadth of the frame of that question and some of the assumptions embedded in it just make it difficult for us to provide an answer, and the officers aren't indicating they have anything specific to offer up in response to your question.
Do you think so? We'll go to that one individual circumstance first, but my question is broader than that, as you've noted. Effectively, you've got a pool of funds that union members must make contributions to, right? And then those funds are then being used for union projects rather than for worker benefits. Does the department see that as a problem?
Again, Senator, embedded in your question are a number of assumptions about who's running projects and who benefits. And I think if there's a specific thing you'd like us to address, we'd be happy to.
Okay. I'm noting that it's not an area of the department's responsibility in relation to those funds. It's something that ASIC has taken action about.
But the area of entitlements is a matter for the department.
Obviously the department would believe that people should comply with the law, and that the department's very concerned to see that employees get their entitlements under those portable funds. Because we're not involved in that work, we don't know or have any, and so are unable to form a view about whether or not it's put at risk, but I take it hasn't. I haven't seen that in the reporting, notwithstanding I've seen the reporting about the write-down that you're referring to.
Right. Okay. So effectively we have a scenario where we have $23 million worth of worker entitlements that were used to create a wellness centre. They were not used and the money did not go back to the workers. And now that wellness centre valuation has come in at around a third. So effectively 2/3 of that $23 million worth of worker entitlements are now lost. Yeah. So from an entitlement perspective, does the department have a problem with that?
Senator, I appreciate the information you're recounting is serious. It's not a matter that we have direct knowledge of. And so we're not in a position to add any evidence about it. I gather, I don't have the article in front of me, that you've referenced that that there are some allegations that have been made and that they're being looked at. We're just not in a position to add in a meaningful or helpful way to the public record on this because it's not our role, and it's not something that we have particular knowledge of.
I also suspect there's a slight difference between entitlements and money in the fund, in the sense that it can obtain funds based on its investments as well. So I'm not aware of reporting that says, for example, members of CFMEU are not getting their entitlements as a result of that action. I think it's an important distinction in between. You're saying people aren't getting their entitlements. I'm not sure the article
No,
said
I didn't say they weren't getting their entitlements. What I was saying is that those monies that they've put in have actually gone to the construction of something that has then been significantly devalued, which then impacts their entitlements. If you lose 2/3 of $23 million, I would suggest that is going to have an impact on someone's entitlements.
But that isn't the point here. That's exactly what the administrator is now having investigated. That is exactly the concern. And I might take the opportunity to remind you, Senator, that this is only happening because it was a Labor government that enabled this union to go into administration. We are uncovering scandal after scandal involving this union, and action is now being taken. Now, to go back to the point you were asking about earlier about, should people have expelled certain union officials sooner than they have, John Setka was in power for the entire time the coalition government was in power. For the entire time the ABCC existed, nothing happened. He's now gone. Michael Rabbar, gone. The Greenfields, gone and in jail for corruption. None of that happened under a coalition government. And Mr Wilson, who I know is supplying you these questions, might like to be an armchair critic of what's going on now, but none of this happened under a coalition government or an ABCC that existed for 10 years. It's a good thing that this is being investigated, and that's exactly what the administrator is doing because of what a Labor government did.
I think that the rest of the individuals here probably don't want to be exposed to a debate between you and I on this matter, Minister, but I take your note. Could I also ask if there's a report date for the Palace report? An expected reporting date?
I don't
Do we know? We don't know? Okay. All right. My next questions relate to some questions around the UWU. There was a recent report from Claire Armstrong from the ABC published on the 20th of November about connections between the United Workers Union, its secretary Tim Kennedy, and a fundraising company called 1R21 Limited. Is the department aware of this issue?
Senator, I'm not aware of it, and I'd welcome the opportunity to take a look at the article so that the officers may be familiar with the article, but I haven't personally looked at it. So if you could get that tabled.
Yeah, sure, we can get that tabled for you, not a problem. And then I'll come back to those questions afterwards.
That's what I'm thinking, yeah.
I'm now going to ask some questions in relation to the Victorian Government working from home proposal.
Senator, we might just change up the bench while you frame your question.
No questions about employer corruption in the construction industry?
I'm not finished yet, Minister.
Sorry?
I'm not finished yet.
Oh, so you do.
Where I might go
you
now.
do have some questions about employer corruption in the construction industry.
Don't want you to enjoy yourself all at once.
Well, as you know, I'm a guy who likes balance.
Are we waiting for...
Yes, we are.
To come
It appears they were sitting right at the back of the room, Senator.
So it's my fault. I should have indicated. So required. Sorry, Chair.
We do our best to anticipate your running order.
I was going to call it German. Welcome.
Oh, do you need to rotate the chair?
Do we have any questions going on?
I do have one, but...
Oh, why don't give you... No, well, you've called the witnesses.
Yeah,
so
sorry, yeah. And then after this,
let's go, yeah.
let me know when and then
we'll give you
rotate.
a break.
Perfect.
Well, not much of a break, sorry.
Does the department have a work-from-home policy?
Oh, sorry. A work-from-home policy?
Yes, yeah.
Are we on our work
Yes,
from
with
home
the department.
policies
Yes,
now?
we do.
Senator, so we have moved on from our cross-portfolio where we would usually and have historically answer these questions, but yes, we do have flexible work policies, and I actually think we've tabled them as part of questions on notice in the last round. Yes.
Excellent. Has the department prepared any advice for the minister on the Victorian government's proposal for a minimum 2 days of working from home?
Senator, Diab Hub, First Assistant Secretary of Employment Conditions Division. We have not.
You haven't? So no advice has been sought in relation to that?
Not that I'm aware of, no.
Okay. Was any advice provided to government on the risk of constitutional challenge arising from this? Or was it sought in any way?
I think we step back, Senator. I'm not aware of the detail of the proposal. I don't think Victoria's come to formally consult us, for example. So we're aware generally of the constitutional issues in relation that arise in industrial relations space, but haven't, for the reasons myself and Mr Hub have outlined, haven't had to brief specifically on them.
But has any advice been provided to the federal government in relation to potential risks from the Victorian government making those decisions?
No, I haven't sought advice.
None? Okay. Has the department sought or received legal advice from the Attorney General's Department or the Australian Government Solicitor on the constitutional validity of the Victorian government's proposal?
No, Senator. It would be tight work to the Australian Government Solicitor given it's constitutional, but as I said, given we haven't been formally received, formally consulted ourselves, we haven't got a specific proposal that we've sought advice on.
Thank you. Has the department considered advice on whether the Commonwealth could override or harmonise such a law through federal legislation?
Oh, sorry, Senator. I was just going to, because we're of the course of the questions, I was going to get Ms Godden to come back from our legal area and get perhaps Mr Hart to step aside, just so we've got people who can cover the full range of questions you're asking. I'll get you to repeat that last question, please.
Of course. Has the department considered advice on whether the Commonwealth could override or harmonise such a law through federal legislation?
So because we haven't sought advice, we haven't considered advice. As I said earlier, we're aware of the issues generally, but we haven't gone and sought specific advice based on a proposal put to us from Victoria.
Right. So there's been no work done on this or no thought put to it in terms of the implications from a Commonwealth perspective, or even if perhaps there was a potential High Court challenge if the Victorian government were to legislate a proposal like this?
Certainly not to that level of detail, Senator, but we are aware of the media reports. We have read the media reports. We have consider those a very high level internally, but as Mr Manning said, without a proposal to consider, it would be premature to take steps such as seeking advice from the Australian Government Solicitor, because we're not sure what we would be seeking advice on in terms of what the proposal is. Okay. Then if I go from an operational perspective rather than a legal perspective, and given that they are reports without any, as you say, particular detail that you are aware of, have you considered, or will the department then be required to put their minds to any potential economic impacts of mandating 2 days a week working from home? And what would be the normal course of events with something like that?
I'm Anshu De Silva, Wijaratna, Assistant Secretary, Equity and Titles International Branch. Senator, these reforms are ultimately a matter for the Victorian Government and the Victorian Parliament. Clearly, the Commonwealth has an interest in terms of the interactions with the Fair Work Act framework.
Well, correct, yeah.
But those would be matters that we would be sort of considering from both a legal perspective and, to the extent necessary, a broader policy perspective. If and when the Victorian Government decides to proceed on the basis of those consultations, and depending on what the outline of that is, bearing in mind, of course, that there are also arrangements in place that do go to the referral of powers and to what extent Victoria can legislate in this space and to what extent the Commonwealth can legislate in this space.
And would it be usual for them to have consulted with you before this time, particularly in relation to any implications in relation to Commonwealth requirements, or is that not usual for them to do that, or for any state to do that when considering some kind of legislation of this scale?
I don't think there's a one-size-fits-all approach. I suspect once if and when they form a view about the approach they want to take, they might do it. When it's going back a little bit now, but when it was first reported, there were reports from memory of different options for different ways they might seek to do it. For example, using their anti-discrimination legislation was one, standalone legislation was another. So I suspect they'll think about it and undertake some consultation and then potentially come with a more specific proposal. That's what I'd expect. So yeah. So there's I don't think it's a matter where you could say what would be normal or usual.
Okay, all right. If you're happy to rotate now, Chair.